the chair of the committee intends to dissuade the House that there is no dissenting report. There is a dissenting report that was submitted to the chair of the committee, and rightfully so, he should have probably made us aware that it is there and almost signed by half of the committee.
The chair will bring it that. Just be patient, it will come. The chair, after reading his report, will call for the dissenting what? Views.
I have been handed over the minority report. I wish to lay the minority report. And there was no intention whatsoever, but the fact is, if there is a second
you
one,
proceed.
you present. Right, Honorable Speaker.
Honorable members, stop smuggling minority reports in the House. The reports must be received, we upload them, and we handle them.
Thank you.
Nobody will be denied to present a minority report, but just bring them in a formal way.
Right, Honorable Speaker, I wish to present the report of the Consolidated Committees of Defense and Internal Affairs and Legal and Parliamentary Affairs. This bill addresses the policy principles, and briefly, it streamlines the composition of the defense forces and establishes healthcare service for its members. The bill creates a medical board. It defines service offenses. It defines...
A report is being presented.
Let him finish his report.
Yes.
Hansard, capture all the reports. Capture all the reports. Yes, Honorable Wilson, go ahead.
Thank you, Right Honourable Speaker.
Are you Wilson? What is it?
Right Honourable Speaker, I'm raising. I sit in the Committee of Defense and Internal Affairs. Right Honourable Speaker, you gave the committee the task to look at the bill and come up with the report. And when we were writing the report on Monday, before we reached half of our report, the chairman told honorable members that they are going to Entebbe to attend the caucus, and they will come back. We shall continue with the report. Right, Honourable Speaker, the chairman did not come back, and we did not continue with writing our report. Is it possible, right, Honourable Speaker? I don't know where the report came from. Let the chairman clarify to members, because we did not complete writing our report on that day. Right, Honourable Speaker, we need to be very serious. And it's so bad to keep on smuggling what is not agreeable by honourable members. Where did you get this report from? Yet the committee did not complete. Right, Honourable Speaker, let us put the record right. In fact, we did not complete working on this report. And we did not process it.
Honorable, where did you get your dissenting views for you to write a minority report? Because the minority report is, say it. The minority report is signed by you. Where did you get the dissenting views? Chair, continue.
Thank you. In its composition of defense forces, it establishes the health care service of members. It creates a medical board. It defines service offenses, military courts, and reserve force, while restructuring the courts martial per Article 129, 1D of the Constitution. The proposed qualifications of the chairperson of the courts martial to ensure independence and allow for appeals. This bill specifies circumstances under which civilians may be subject to military law and outlines the offenses tried under courts martial. Additionally, Right Honourable Speaker, this bill establishes a military courts department, a disciplinary unit for enforcing discipline within the military court system. It prescribes defense forces exclusive arms and ammunition. It manages veterans' affairs and repeals the Uganda Veterans Assistance Board Act Cap 221 and release. The Uganda People's Defense Forces has provided under Article 2010 of the Constitution, replacing the Armed Forces Pensions Act Cap 295 and Uganda People's Defense Act Cap 307. Notably, the defense sector has undergone significant transformation since 2005, driven by emerging threats and opportunities, many of which the Act does not adequately address. The Act did not include health care for the officers and militants, management of military veterans, pensions management, or service medals conferred by defense forces. Since 2005, the UPDF administrative structure has changed significantly, with Special Forces Command and Reserve Force elevated to independent services. The Uganda People's Defense Forces Amendment Bill 2025 reflects this evolution. Additionally, Right Honorable Speaker, the bill seeks to align the Act with the Supreme Court decision in the Constitutional Appeal number 2 of 2021, which is Attorney General versus Honorable Michael Kabaziguruka. What are the objects of this bill? It seeks to amend the UPDF Act Cap 330 to streamline the composition of the organs and structures of the defense forces. It establishes the health care service for members of the defense forces. It establishes a medical board. It provides for the definition of service offenses, the court-martial, military court, and reserve force. It provides for the restructuring and establishment of the courts-martial in the defense forces in accordance with Article 129(1) of the Constitution and prescribe for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the courts-martial and the independence of the courts-martial. It provides for appeals from the courts-martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offenses for which civilians may be tried by the courts-martial. Honorable Speaker, this bill provides for the establishment of the military courts department within the defense forces. It also further provides for the establishment of a disciplinary unit within the defense forces, which shall be responsible for the discipline of the members of the military courts department. Also prescribe the arms and ammunition which are a monopoly of the defense forces and classified stores of the defense forces. It also provides for the management of the Veterans Affairs. It also repeals the Uganda Veterans Assistance Board, Cap 221, and for related matters. Right Honorable Speaker, for the record, we consulted as is demanded by the processing of the bill. We met and held discussions, constructive ones, with stakeholders, like the Ministry of Defense and Veterans Affairs. We also met the Attorney General. We held discussion with Office of the Director of Public Prosecutions. While processing this bill, Right Honorable Speaker and Honorable colleagues, we also entertained private legal practitioners. In this case, Counsel Jude Byamukama. We also entertained and granted audience to Kampala Reduction in Force veterans of the UPDF, who gave us enriching perspectives and testimonies. We did document review. We looked at the Succession Act. We looked at the Constitution of the Republic of Uganda. We looked at the Defense UPDF Act, Cap 330. We looked at the Pension Act, Cap 89. We looked at the Uganda Veterans Assistance Board, Uganda Veterans Assistance Board Act, Cap 221. We looked at the Human Rights Enforcement Act, Cap 12. The following are the salient observations on the bill. 1. Military justice and legal framework of the courts-martial. The committee recognizes that one of the objectives of the bill is to implement the Supreme Court's declarations in Attorney General versus Honorable Michael Kabaziguruka, Constitutional Appeal number 2 of 2021, delivered on 30th January 2025. The committee has reviewed the bill's proposals on military justice and court-martial framework. The findings reveal concerns about compliance with constitutional principles, judicial independence, and administration of military justice. 611, the trial of civilians under military law. Clause 29 and Clause 30 of the bill address individuals under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all defense forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the defense forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of defense forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such a trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independent independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offences. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the court. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces, in consultation with the High Command, to assign an acting rank to the head of the General Court Martial when the accused has a higher rank. While intended to maintain order, this mechanism may introduce bureaucratic delays and allow manipulation of the justice process. For instance, the Chief of Defense Forces could delay rank assignment impeding the prosecution of senior officers. The temporary rank, with its associated privileges, may also incentivize judicial officers to prolong proceedings to retain benefits, hence compromising timely and impartial justice. The committee therefore recommends that the proposals contained in the bill regarding composition and structure of the military courts should be supported, albeit with amendment to engender fair trial provisions as proposed in the committee's amendments. Appointment of the presiding officers and members of the courts martial. Right Honourable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the
Is
bill...
it 129 or 128?
120, I beg your pardon.
Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here when... Is it in order for them to continue defying the ruling that you made, that this front seat be reserved for the members? Is it in order?
Honorable
I'm not speaking.
Abim, you extend, you're disturbing Junior.
The Right Honourable Speaker and members, I move to present the minority report. But prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the Joint Committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner, haphazardly, reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide, okay.
While I finish my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
There's an order.
Thank you very much, Right Honorable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and that it is only him who is illogical in this House? When we represent our different constituencies, is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with the reason and with the logic. And these are honorable members of Parliament. So whenever there is a debate here, it is done with the logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honorable Speaker, I withdraw.
Honorable members, allow me to chair the House. Junior has withdrawn the statement and will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honorable members of Parliament. Yes, Junior.
Right,
you go and look for them.
Right Honorable Speaker.
Junior, continue.
Right Honorable Speaker, if the House may please, I'll read.
Read your report.
Right Honorable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defense and Internal Affairs on the decision of the majority in respect of Uganda People's Defense Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025. And in accordance with the Rules 134 and 200, referred Joint Committee of Parliamentary Legal Affairs and that of Defense for scrutiny. The object of the bill is to amend the Uganda People's Defense Force Act, Cap 330, to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabaziruka is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9, by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabaziruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016. As a locus classicus case, in addition to other authorities, the point of dissent are: 1, contravention of the Constitution; 2, illegality in military trial; 3, offending the doctrine of separation of power; 4, lack of public participation; 5, unconstitutional expansion of the military court's jurisdiction; 6, constitutional limitation on Parliament's power; 7, lack of independence and impartiality of the court-martial; 8, non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honorable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the Defense Force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the Defense Force which is in active service in any place; B, where while serving in Defense Force under the engagement by which he or she has agreed to be subject to military law; C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law. D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, prison of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the Defense Forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the Defense Force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the courts. See Article 28(2) and 3 of the Constitution. This action amounts to contempt of the Supreme Court, which is criminal, a path that must be avoided by a decent parliament. Right Honorable Speaker, in a locus classicus case...
Do you have to ask to add a decent parliament? Must you add decent? Nobody doubts that we are decent.
Avoided by our parliament.
So
most obliged.
Expand the word decent.
In the locus classicus case of Liange versus the Queen, 1967, the Sri Lanka Parliament passed a retrospective law affecting the trial of individual accused of attempted coup. The Privy Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Coming down, there were other authorities that, Right Honorable Speaker, and colleagues, there were other authorities that were cited year after to persuade the House. I urge members to peruse through while I go to deal with the second area of dissent. The second area of dissent is illegality in military trials. Your Honor, Right Honorable Speaker, the question of illegality in military trial is ably canvassed by the Supreme Court in the case of Michael Kabaziruka in the above case. Owindolo CJ, in his lead judgment at page 180 and to 185, add this to say, Your Right Honorable Speaker. There are also other vital reasons militating against trials of persons subject to military law for all offenses. These courts has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offenses. For instance, since terrorism cannot only be tried can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Your Honor.
Honorable Justice, Chief Justice Owinjidolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the
Right,
court
Honorable
first.
Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right, Honorable Speaker, the CJ, Justice Owinjidolo, in his lead judgment at page 180 to 185, had this to say. Open quote. There are also other vital reasons militating against trials of persons subject to military law for all offenses. This court has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on a court-martial jurisdiction to try such an offense. For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well. And also, it would be self-defeating for an offense similar to terrorism to be created under the UPDF Act, and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still correct position of the law, and where jurisdiction is expressly excluded or where the DPP's consent is a prerequisite, the court-martial are not competent to handle that matter, so excluded irrespective of the provision to the contrary. Under the impunged section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offenses, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. As already noted, the General Court-Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where he held that the General Court-Martial is subordinate but not lower than the court-martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129(1)(d) can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court-martials of offences within the jurisdiction of the court-martial is unconstitutional under Article 28(1), 44(c), 128(1), 129(d). Close quote. The general rule is that ordinary courts alone have jurisdiction to try civilians. The Supreme Court was unable to find any justifiable link between the need to maintain discipline in the army or maintenance of security of Ugandan borders and trials of civilians in the military court tribunals generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179(1), 2, and now 171(1) and 2 of the UPDF Act.
Is it 171 or 177(1) and 2?
179(1) and then 1 and 2, and then 177(1) and 2 of the UPDF Act. Read together with 197(2) and now 197(2), which grants subordinate military courts jurisdiction over capital offences, contravenes Article 129(1)(d) and Article 126(1) of the Constitution. Hence, they are unconstitutional. The consent of the DPP. 5. Civilians cannot commit or be tried for service offences even when they abet or aid the commission of offences. 6. Where civilian and military personnel have committed a crime other than a service offence, both be tried in civil courts. In 7, Parliament cannot duplicate offences prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent, independent, fair, impartial court or a tribunal. With a decision of the Supreme Court, the trial of persons with offences within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes, therefore, without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honorable Speaker and members, let me conclude on this note. Court martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. Per Justice Catherine Bamogemere, Justice of the Supreme Court, at page 41 of our judgment.
Of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial stroke military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offenses committed by the military person. The next point of the dissent is on limited or exceptional circumstances, as it has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the Constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be constitution in force. Two, courts of law have no capacity to try the offenses. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda? And why not deal with the root causes of it all, which is the security of the judicial officers, rather than recourse to the courts martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make...
At least not everybody is foolish.
No, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans, Madam Speaker, to make all Ugandans liable for trial in the military justice system, first of all Ugandans must become militants and officers with proper and officers. That first, let's provide for a law for all Ugandans to become militants and officers with proper training in aspect of militarism, with each one of the Ugandans being formally passed out by the Commander-in-Chief, and we are kept, all of us, as the reserve force. The laws of Uganda can then be amended accordingly to provide a concrete basis for such an arrangement. The minority is saying that once all Ugandans are militants, then it is possible to provide for court-martial so that we are all trained and we know we are soldiers. The finding. The minority finds that there are no limited or exceptional circumstances existing in Uganda at the moment, as the constitutional framework and other legislations are in force and they are adequate to deal with all criminal matters before the civilian courts. The minority further finds that military disciplinary offenses, as provided in Part 6 of the Principal Act, can be exclusively tried in the court-martial or other disciplinary mechanisms within the command structure of the UPDF. On issue number 2, on whether the...
Honorable Odur, first of all, Article 119, Sub-Article 3 and 4 gives the Attorney General powers to be the legal advice of government, and where you said I should be the one to answer all the legal requirements or legal questions. I have never been the legal advisor of government. I will now ask the legal advisor of government to respond to all the issues raised in the two minorities, and secondly, on the issues, stop merrymaking, on the issues of sub judice, I can only determine whether there is sub judice when I have been informed of an active civil or criminal case, and that is provided for under Rule 75. I will not go on a fishing expedition to find out whether there is a case somewhere, so that can only be answered by the Land Attorney General. Over to you, Land Attorney General.
Versus the Attorney General of the Republic of Uganda, who is the respondent. It is duly stamped by the Minister of Justice and Constitutional Affairs, Directorate of Civil Litigation. I beg to lay on table and invite that it's a...
You can lay it, but I've only gotten to know it now that it is the case. Attorney General.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, two cases that are in the... one case in the East African Court of Justice and another one in the Supreme Court. Right Honorable Speaker, I have had the opportunity to read these two decisions, and I really wonder how someone can actually think it touches on this matter. Because these matters in court, I wonder how we can even think it attaches to the matter before this Parliament. The orders being sought in Marema Birizi are to actually quash. Marema Birizi went to the East African, rather Uganda Law Society went to the East African Court of Justice to quash the decision of the Supreme Court. So when you say that we are discussing an amendment, he's not even discussing whether or not you should amend or not amend. He's saying just quash that decision. So if we quash that decision of the Supreme Court, it cannot be a matter that is sub judice, because it will then not even affect the conversation we are having. The second one, Right Honorable Speaker, is a matter of contempt. Honorable Mr. Malema Birizi has taken a matter to the court saying that by the Parliament carrying out this activity of amending the UPDF Act, it is in contempt of court. Right, Honorable Speaker, you are damned if you do and damned if you don't, because the Supreme Court did order you to amend the law and bring it in compliance with the decisions of the Supreme Court. That's what we are doing here. Now, for someone to say that we should not do it because we shall be held in contempt, you'll be held in contempt if you don't. So, the conversation we should be having here is whether what we are doing is in compliance with what the Supreme Court ordered. But to say that we should not do it, I think that would be superfluous, and I hope Honorable Odur does agree with me that we must handle this matter. The conversation of what we need to do, what amounts to what is in compliance with the Supreme Court decision, will require us to look at those provisions that are being proposed by the executive, and then we can have a conversation as to whether they comply or they don't comply. But if you say we should not look at them, then you will not even know whether they comply. Right, Honorable Speaker, that is my response on the question of sub judice. Then there was a question whether there was a lead judgment. Yes, Right Honorable Speaker, I did write under my hand that there was a lead judgment which was given by the Honorable the Chief Justice, but at no point did I even intimate to any member that read only that judgment. You see, when you're dealing with appellate decision, especially where you have 7 justices, you must read all the 7 justices and determine what each one said on that point. You could have a lead judgment where the 6 judges don't agree on a particular point. So I think it is important that as we go through this, I have personally had the opportunity to read all the 7, and I can see you have relied on one judgment, but I think it's important for us to look at all the 7 so that we are clear as to what the court said. The judgment of the lead judgment must be supported by the majority of the other judges on every point that you address. So it is not to say that whatever the lead judgment says must be followed as the final judgment. So, and I think what we have done in this is we have looked at all the judgments and tried to bring them into context. Yes, it is true, Right Honorable Speaker, that I did interpret the decision of the Supreme Court in the letter my learned friend Honorable Odur raised of 3rd February, and yes, I did state that our understanding of the Declaration 7, 8, and 9 of the court is that civilians could not be tried in the military courts. Right Honorable Speaker and Honorable colleagues, the military courts that I was referring to are the ones that exist now. The ones that exist now. If this Parliament is pleased to amend the law and give the military courts the tenets that the court guided us on, the tenets on the independence, the tenets on the oath, the tenets on security of tenure, and all those things that we discuss in the Parliament, then I do not think that it will be contrary to the Constitution, because the tenets that are required under Article 128 and Article 28 would be complied with. Right Honorable Speaker and Honorable colleagues, I have not read anywhere in the proposed amendment that the General Court Martial is being given unlimited jurisdiction. Actually, it's being given jurisdiction as set out in the law. So when it says that, for example, you will have the authority to try offenses under any written law, it is the High Court which has unlimited, but some of these offenses are actually tried by magistrates, G1. There are other offenses that are tried by magistrates, chief magistrates, and others are tried by the High Court. When they say that the High Court has unlimited jurisdiction, it just simply says that the High Court can try even that which the G1 can try, but did not say that no one else should try those offenses. So, being subordinate equal, the GCM does not have jurisdiction which is unlimited. So the jurisdiction of any court in this country is granted by Parliament. No, by Parliament. Let me finish so we can have jurisdiction is granted by Parliament. Even the jurisdiction of the High Court, ladies and gentlemen, is granted by Parliament under the Judicature Act. Even the Magistrates Courts Act is under that grants the jurisdiction. If you remember some time ago, we have started the process of amending the pecuniary jurisdiction of Magistrates Court. That must come to the Parliament. It's not in the Constitution. So the Constitution said there will be these courts, but the granting of jurisdiction is supposed to be granted by Parliament. Yes, it is true, Right Honourable Speaker, that I was asked whether I would trust both courts. And yes, I did say I would trust both, but I think what Honourable Du forgot to answer is that even in our system, we like to go to the professionals in that space first, then go to the generalized courts. We have the electricity disputes tribunals, we have the tax appeals tribunal, we have the industrial court. All those are specialized. Now, in this case, the matters we are dealing with is specialized in dealing with military equipment. I think the profession, the best person who is best professed with the mandate to deal with the military equipment is the Army. So we are saying that when you deal with military equipment and stuff of military nature, deal with the Army first, then come out to the courts, just like we do in other specialized spaces.